Thank you. Yes, please. Yes, appearance for the defendant. Neil. Mr. Mohammed, is the defendant represented?
My lord, I informed them this morning. They called me this morning. Said they get
Are they in court? Is the defendant represented right now?
I'm not sure, sir.
Is a yes or no, please? Are they in court?
No.
Thank you.
Okay, my lord. They called me this morning.
Okay, I'm going to take this judgment from the point of my decision in order to save screen time.
Yes,
sir.
And I'll proceed straight away. In determining this suit, I will consider the issue whether the claimant has proved his case and entitled to the reliefs he sought in the suit. There is no dispute in this suit that the claimant was employed by the first defendant. The claimant's employment letter is Exhibit A, dated 29th August 2008. The claimant was employed as a motor driver mechanic. In his evidence, the claimant said his employment with the first defendant is regulated by statute, the Public Service Rules, 1999 Constitution, and other laws. Other than his continual reference in his evidence to his dismissal not being done in compliance with the Public Service Rules, the claimant did not mention the statute or any other law or provision of the 1999 Constitution which regulated his employment with the first defendant. In paragraph 6, 8, and 11 of the defendant's amended statement of defense, the defendants pleaded that the claimant was disciplined and dismissed in accordance with the Public Service Rules. The defendants have accordingly agreed that the Public Service Rules was applicable to the claimant's employment with the first defendant. From the pleadings and evidence of the parties, it is not in dispute that the Public Service Rules regulated the claimant's employment with the first defendant. The Public Service Rules is considered to be a subsidiary legislation. See Federal University of Technology, Yola, against Mewuya, 2013.
Oh, this is it.
Sorry, please. Yola, then thus it conferred the employment to which it regulates employment protected by statute. See Nawa against Attorney General, Cross River State, 2008. Okeme against Civil Service Commission, Edo State, 2001. Now, in relief one of the complaint, the claimant sought a declaration to the effect that his employment with the first defendant is regulated by statute. In view of the evidence showing that the claimant's employment is regulated by the Public Service Rules, the declaration sought by the claimant in relief one succeeds, and it is accordingly so declared. The crux of the case of the claimant is the alleged termination of his employment. The claimant alleged that his employment was unlawfully terminated by the defendants. In his evidence, the claimant said, alleging that he attempted stealing a 2 HP split unit air conditioner from an open space on 24th April 2012. He responded to the query on 2nd May 2012, wherein he denied the allegation. After his reply to the query, he continued to perform his duties in his office without any further action on the query until he observed that his salary for April 2013 was not paid. And when he inquired, he was told that he had been dismissed. He has not been paid salary since then, and he has not been allowed to return to his duty post since May 2013 by officers of the first defendant. He made several attempts to resume duty, but he was not allowed into the office premises. Letters were written to the defendants requesting to be allowed to return to his duty post, but there was no response to the letters. The claimant also stated that after his response to the query, no further action was taken on the incidents except to forcefully stop him from performing his duties from May 2013. And during the period, he was not given letter of suspension or dismissal or informed of termination of his employment in any way. From the evidence of the claimant, he averred that he was not given any letter of dismissal or termination of his employment by the defendants. His basis for alleging termination of his employment is his averment that he has not been paid salary from April 2013 and he was disallowed from entering into the office premises of the defendants since May 2013 by officers of the defendants. In their defense, the defendants averred that when the claimant was found to have committed theft of government assets, it led to the termination of his employment by the first defendant. Thus, the claimant's salary was stopped after the claimant's employment was terminated. The defendants further aver that the claimant was lawfully dismissed from service of the first defendant as he was in breach of the contract of employment by abdicating his duties since 2012/2013. By their averments and the evidence of DW1, the defendants confirmed that the claimant's employment was terminated on account of the allegation of theft made against the claimant. They also confirmed that the claimant's salary was stopped because of the termination of his employment. The defendants, however, did not mention when the claimant's employment was terminated or when the claimant's salary was stopped. Although the defendants admitted that the claimant's employment was terminated, they did not produce or show any letter of termination of the claimant's employment to this court. In any event, whether a letter of termination of the claimant's employment exists or not is not material. The material fact which is not in dispute is that the claimant's employment was terminated by the defendants and the claimant's salary was stopped as a consequence. The claimant testified that the stoppage of his salary happened in April 2013. He said after the query to him, he received his full salaries from April 2012 to March 2013. But his salary was stopped in April 2013, and it was from May 2013 he was stopped from attending work. The failure of the defendants to state the date of termination of the claimant's employment or the date of the stoppage of the claimant's salary renders the evidence of the claimant on the dates these acts occurred undisputed. The implication is that the claimant's employment was terminated effectively in April 2013. According to the claimant, the reason for the termination of his employment is the allegation of attempted theft. I have seen some inconsistencies in the evidence of the defendant with respect to the termination of the claimant's employment. At one point, the defendants averred that the claimant's employment was terminated and his salary stopped because he was found guilty of the allegations made against him. In another breath, the defendants have said the claimant's employment was terminated for being absent from work for a long time at his own volition because he was not at ease with the allegation leveled against him. These are contradictory evidence as to the reason or ground for the termination of the claimant's employment. The defendants seem to claim that the claimant abandoned his employment even before his employment was terminated. The defendants averred that the claimant absconded from his duty post before his dismissal. I have said earlier that the defendants did not mention the date the claimant's employment was terminated, but taking the date of the stoppage of the claimant's salary, the termination is deemed to have occurred in April 2013. Now, when the defendants alleged that the claimant absconded from his duty post before his dismissal, what the defendants have said in effect is that the claimant stopped going to work before April 2013. The claimant disputed this allegation when he said that since his reply to the query on 2nd May 2012, he continued to attend work and discharge his duties, and he was on his duty post till May 2013 when he was stopped from entering the office by the officers of the first defendant. The query was issued to the claimant on 2nd May 2012. The claimant was paid salaries till April 2013. That is to say, the claimant was paid salaries for 1 year after the query. The defendant's witness also told this court that the claimant appeared before a disciplinary committee hearing after the query. The date of the disciplinary hearing was not mentioned, but it is clear that the claimant was still attending work after the query and at the time of the disciplinary hearing. Now, when the defendants alleged that the claimant absconded from duty, when exactly did he abscond from duty? The defendants did not say, and I am not about to engage in a worthless exercise of finding when the claimant allegedly absconded from duty. The evidence before me clearly shows that the claimant was being paid salary up to March 2013. This fact is a clear indication that the claimant was working for the defendants from the date of the query up till March 2013. It is my view that if the claimant had abandoned duty since the query as alleged by the defendants would not have paid him salary up to March 2013. By paying the claimant salary up to March 2013 is an acceptance by the defendant that the claimant was attending work in the months he was paid salary. Now, at what point did the claimant stop work with the first defendant? The evidence adduced before me shows that the claimant's salary was stopped in April 2013, and in May 2013, he was prevented from resuming duties. These were the conducts of the defendants which terminated the employment of the claimant. The claimant, from the facts, stopped work with the first defendant in May 2013. Any allegation that the claimant abandoned his employment after May 2013 will not only be frivolous, it will also amount to an act of mischief. Which employment did the claimant abandon? Is it the same employment that had been terminated? How can the defendants who terminated the claimant's employment in April 2013 for attempted theft thereafter accuse the claimant of absconding from the same employment which has been terminated? I have seen the evidence of the claimant where, after he was stopped from entering the office in May, he made attempts to resume duty, but still he was not allowed to resume and render duties to the first defendant. The evidence of the claimant in this respect was not challenged. I have also seen the claimant's letters to the first defendant pleading to be allowed to resume duties. These are exhibits F and G, dated 24 June 2019 and 26 November 2019, respectively. These letters were not replied by the defendants. In my view, the claimant, who is alleged to have unilaterally abandoned his employment and duties, cannot be pleading to be allowed to resume duties. Contrary to the allegations of the defendants, I am convinced by exhibits F and G that the claimant did not on his own accord abandon duties. The claimant's employment was terminated by the acts of the defendants. Also, the claimant's employment having been terminated for the reason of the allegation of attempted theft, I find the explanation of the defendants that the claimant's employment was terminated for abandoning his duty to be ridiculous and an afterthought. I also find the defendants to be uncertain of their facts. In fact, it is clear to me that the allegation of abandonment of duty never came at any time until the time of filing defense in this suit. The defendants only made up the allegation in defense of the suit. This fact is clear in the averments of the defendants in paragraph 11 of the amended statement of facts of defense. Where the defendants pleaded thus, quote, even if the claimant's employment had not been terminated as a result of his culpability in the allegation of theft, the claimant, having abandoned his duties from 2012/2013, is in breach of his contract of employment and entitled to dismissal under the public service rules. From this averment, it is clear that the claimant's employment was at no time terminated for reason of abandonment of duty. Rather, the reason for the termination of the claimant's employment was the allegation of attempted theft. Obviously, the defendants speak from both sides of their mouth. This attitude renders the pleaded facts and the evidence of DW1 unbelievable. Without any doubt, the obvious reasons for the termination of the claimant's employment was the allegation of attempted theft of a 2 HP split unit air conditioner from an open store on 24th April 2012, for which he was given the query of 2nd May 2012. Now, the claimant has challenged the termination of his employment on account of the said allegation made against him. According to the claimant, on 2nd May 2012, he was issued a query alleging that he attempted stealing a 2 HP split unit air conditioner from an open store on 24th April 2012. He responded to the query on 2nd May 2012, wherein he denied the allegation. Since his response to the query and up till the time his salary was stopped in April, he was not invited to appear before any committee, and he did not appear before any committee where he could be heard in respect of the allegation made against him. He also said he is not aware of any disciplinary committee set up by the defendants to hear the allegation against him as required by the public service rules. It was before he was given a query that one Mr. TFZZYI was delegated to question him on the allegation. But after his response to query, no further action was taken on the incidents except to stop his salary and prevent him from performing his duties from May 2013. The claimant said he was denied fair hearing in the process, leading to the termination of his employment. He also averred that the termination of his employment did not follow due process and it was not in accordance with the terms and conditions of his employment. The defense of the defendants is that the claimant was issued a query which he replied, but his reply to query did not exonerate him. The claimant went through disciplinary procedure in line with the public service rules, but he was found culpable. The claimant was invited and he appeared before the investigative and disciplinary bodies. The claimant testified during the disciplinary procedure. The defendants averred also that the claimant was given fair hearing before he was dismissed and due process was followed. From the evidence of the parties, it is agreed that the claimant was given a query where he was accused of an attempt to steal a 2 HP split unit air conditioner from an open store, and he replied the query. The quarrel of the claimant in this suit is that after the query, he was not invited to appear before a disciplinary committee to defend the allegations against him, and for that reason, he alleged denial of fair hearing. He also alleged that the termination of his employment did not follow due process and it was not in accordance with the terms and conditions of his employment in the public service rules. The relief sought by the claimant touching on the termination of his employment are reliefs 2, 3, and 4. These reliefs are declaratory reliefs. It is trite that the burden of proof in establishing declaratory reliefs is on the claimant, and he must prove the reliefs to the satisfaction of the court. Declaratory reliefs are not granted as a matter of course or on the admission of the defendant. The claimant is required to establish his entitlements to the declaration by his own evidence, such that even the weakness of the defendant's case will not assist the claimant's case. See Ada against Ubandawaki 2015, Zakala against Edosa 2018, and Dumes Nigeria Limited against Nwakoba 2008. Thus, it is the duty of the claimant who is seeking from this court a declaration that the termination of his employment did not follow the due process of law or the public service rules, or that the termination of his employment was unlawful, to plead and prove the due process of law or the procedure in the public service rules which was not followed, and to plead and prove how the termination of his employment is unlawful. In this case, the claimant merely said the termination of his employment did not follow due process and it was not in accordance with the terms and conditions of his employment with the first defendant. The claimant did not plead the due process or the terms and conditions of his employment which ought to be followed before his employment can be terminated. Although the claimant mentioned that his employment with the first defendant was regulated by the public service rules, he did not plead the procedure or process in the public service rules which ought to be followed. to terminate his employment. The claimant did aver that he was not invited to appear before any committee and he did not appear before any, where he could be heard in respect of the allegation made against him. The claimant did not tell the court whether his not being invited to be heard by a committee is a violation of the requirements of the public service rules or any other condition of his employment. The claimant did not also say there is any procedure in the terms and conditions of his employment that require that a committee be set up or that he should be heard by a committee before his employment can be terminated. It is not enough for the claimant to allege that he was not invited before any committee. He must go further to plead and prove that his assertion is premised on the terms and conditions which regulated his employment. It is upon such pleading and proof that the court will be enabled to examine the condition of service relied upon to see whether the claimant's allegation is substantiated. Where a claimant merely mentions that his employment is regulated by the public service rules without going further to link his allegations to the provisions of the public service rules or to plead and prove the procedure in the public service rules which was not followed during the termination of his employment, it will not be the duty of the court to engage in scrutinizing the public service rules in order to find where the public service rules relate to the claimant's case. The claimant's allegation of denial of fair hearing is based on his allegation that no committee was set up and he was not invited to be heard by any committee. This allegation of denial of fair hearing also cannot stand alone without linking it to a breach of the terms and conditions of his employment. The claimant cannot succeed on the allegation of denial of fair hearing without proving that the breach of that fair hearing arose from breach of the terms of the condition of service. It is trite that an employee in statutory employment challenging his dismissal from an employment cannot found his case solely on the allegation of denial of fair hearing. The employee must, as a condition precedent, base his case on the condition of service by pleading and proving the terms and conditions of his employment, and then show in what manner his dismissal breached the said terms and conditions of the employment. See AG against Charge Basin Development Authority 2016. In this case, the claimant's allegation of denial of fair hearing has not been based on any breach of the procedure in the condition of service or the provisions of the public service rules regulating the employment. In the absence of pleading and proving the terms or procedure in the employment allegedly not followed in terminating the employment, the claimant has failed to prove that the termination of his employment breached any term of his employment or his right to fair hearing. Without a doubt, the terms and conditions of a contract of employment are the foundation for a claim for unlawful dismissal or termination of employment, and the terms and conditions of the employment must be pleaded and proved by the claimant. In AG against Chad Basin Development Authority, Supra at page 190 of the report, it was held thus, quote, whether one is suing for wrongful dismissal from an employment with statutory flavor or under common law principle of master and servant, the fact of the employment and the terms and conditions of same must not only be pleaded but must be proved by evidence before a determination of the wrongful nature of his termination stroke dismissal can be considered by the court, unquote. Let me mention that the manner the claimant's employment was terminated by the defendants leaves much to be desired. The claimant was given a query in April 2013 and then in April 2012. And then in April 2013, his salary was stopped and he was thereafter prevented from attending work. The claimant was not given any letter of termination of his employment or letter of dismissal. His employment was simply terminated by the conduct of the defendants. According to the claimant, no disciplinary proceeding took place. Unfortunately, the determination of the matter does not stop at this conduct of the defendants. The law places a duty on the claimant to plead and prove how these conducts of the defendants violated the condition of service. It is only after the claimant has satisfied the burden of proof that attention shifts to the defendant to justify their actions. The defect in the claimant's case is his failure to plead and prove the procedure for termination of employment in the public service rules, which was not followed when his employment was terminated. Since the claimant alleged that the termination of his employment did not follow due process and it was not in accordance with the terms and conditions of his employment, it is his duty to plead and prove the due process and the terms and conditions of his employment, which the termination of his employment did not accord with. In the absence of pleading and proving the provisions of the condition of service or the public service rules, which were breached in the claimant's dismissal or termination of his employment, the necessary ingredients which the court requires to determine the declarations sought by the claimants in reliefs 2, 3, and 4 have not been placed before the court. Accordingly, I hold that reliefs 2, 3, and 4 have not been proved by the claimant. Reliefs 5, 6, and 7 sought by the claimant result from reliefs 2, 3, and 4. The implication of the failure of reliefs 2, 3, and 4 is that reliefs 5, 6, and 7 also fail. Accordingly, save the declaration is in relief 1, which is made, all other reliefs sought by the claimant have not been proved and they are hereby dismissed. No order as to cost. Judgment is entered accordingly. Thank you. I can't hear you. Your mic is muted. So we can.
Thank you for the judgment, sir.
Thank you. You can get a copy of the judgment probably later in the day or tomorrow, as it will be sent for printing right away.
Thank you, sir.
So can we proceed to the next case straight away?
Yes, ma'am. Case number 2, NSN/ABJ/219/2020 between National Union of Air Transport Employees and Minister of Labor and Employment. Third parties absent.
I'll be with you in a moment. I'm trying to.
Okay, Milo.
Okay, are the parties present?
Parties absent, Milo.
Thank you. Appearances, please. If your mic is muted, you can unmute it and then announce your appearance.
As the call please.
Yes.
Please, my name is
Yes.
Tokpeti
Tokpeti,
my lord.
yes.
I
And
appear
your
for
appearance?
the claimant, my lord.
Thank you. Any appearance for the defendant?
No, my lord, but we served them the hearing notice. They are not been coming, but we have the proof of service here, my lord.
Okay, I'll proceed to the judgment.
As copies.
And again, I'll go straight to the decision part of the judgment in order to save screen time.
As copies.
As
The
copies.
claimant submitted three questions for determination in the originating summons. Upon examining the questions, I have the view that all the questions are to the same effect, which is to consider the provisions of Section 8(3) and 8 subsections 3 and 5 of the Trade Disputes Act, and determine whether the defendant's resolution reached at the end of the conciliation meeting held on 18th March 2020 between the claimant union and the National Union of Hotel and Personal Services Workers, which resolution was communicated to the defendant, to the claimant, via the letter dated 15th May 2020, complied with the said provisions of the Act. In the questions posed by the claimant for determination in the originating summons, the claimant has called the court to construe the provisions of Section 8(3) and 5 of the Trade Disputes Act in determining the questions and relief sought by the claimant in the originating summons. In order to properly determine the questions for consideration, it is necessary to set out the provisions of Section 8, subsection 3 and 5 of the Trade Disputes Act. The provisions are as follows: appointment of conciliator, etc. If a settlement of this dispute is reached within 7 days of his appointment, the person appointed as conciliator shall report the fact to the minister and shall forward to him a memorandum of the terms of the settlement signed by the representative of the parties, and as from the date on which the memorandum is signed, or such earlier or later date as may be specified therein. The terms recorded therein shall be binding on the employers and workers to whom those terms relate. Subsection 5. If a settlement of the dispute is not reached within 7 days of his appointment, or if after attempting negotiation with the parties he is satisfied that he will not be able to bring about a settlement by means thereof, the person appointed as conciliator shall forthwith report the facts to the minister. The above provisions of the Trade Disputes Act are clear and to the point of its subject matter. I do not need to construe it further. What I must say, however, is that the provisions have nothing to do with the trade unions and their jurisdictional scope. The provisions did not also set out any procedure to be followed before the jurisdictional scope of the trade unions can be determined. The provisions are not with respect to the powers of the minister to determine or not to determine the jurisdictional scope of the trade unions. Now, when the claimant submitted question 1 to this court to determine whether by virtue of the provisions of Section 8(3) and 5 of the Trade Dispute Act, the defendant is empowered to determine the jurisdictional scope of the claimant without following the procedure laid down in the Trade Dispute Act, it appears to me counsel for the claimant, who filed the originating summons on behalf of the claimant, did not read the provisions of Section 8(3) and 5 of the TDA when couching the question. If he did, but still decided to frame such question before this court, I will not be in doubt that the act was for mischief. There is no connection whatsoever between the provisions of Section 8, subsections 3 and 5 of the TDA and the issue to be resolved in question 1 of the originating summons. In my view, the issue which the claimant wants this court to resolve in question 1 of the originating summons cannot be determined from the provision of Section 8, subsections 3 and 5 of the TDA. This fact ought to be clear to any lawyer who had diligently read the provisions of Section 8, 3 and 5 of the TDA. I have read the affidavit in support of the originating summons, but I find that it is defective in substance and facts as to how the above provisions of the Act is connected to or useful in determining the questions in the originating summons. To avoid any doubt, this is all the averments contained in the affidavit in support of the originating summons. Following the confusion of the, that is the quote now. Following the confusion of the employees and workers in in-flight catering services companies operating in aviation sector, the claimant prepared a treatise to explain his position and forwarded a copy to the defendant for his record through a letter dated 11 February 2020. The conclusion of the treatise includes an appeal to the claimant's rival union to withdraw its position, including case in court. The letter was not an invitation to the defendant to determine the jurisdictional scope of the unions, since matters on the same issue are pending in court. In a letter dated 9th March 2020, the defendant acknowledged the claimant's letter of 11th February 2020 and further invited the claimant for a conciliation meeting on 18th March 2020. The claimant attended the meeting, whereat it presented its position as already stated in the treatise. The claimant also informed the defendant that there are cases pending in the National Industrial Courts and the Court of Appeal on the issue. On 25th May 2020, the claimant received a letter dated 15th May 2020 from the defendant, conveying resolution reached at the end of the conciliation meeting held on 18th March 2020 between the claimant and the National Union of Hotel and Personal Services Workers. The claimant was directed to be guided by the resolution. The claimant immediately wrote a letter dated 25th May 2020 to the defendant to protest against the content of the resolution. Before the conciliation and the resolution of the defendant, there is a matter pending before the NICN Lagos Division in suit number NICN LA 444/2018 on the same issue determined in the resolution. The suit was at the instance of the National Union of Hotel and Personal Services Workers. After the defendant issued the resolution, the National Union of Hotel and Personal Services Workers filed the resolution in suit LICN LA 444/2018 as additional documents to rely on. I end it there. Now, that is all the facts in support of the originating summons. There's nothing in the affidavit complaining about the defendant's resolution communicated to the claimant in the letter dated 15th May 2020 not being in compliance with Section 8 of the Trade Dispute Act, or that the minister has no powers to make the resolution. There is no reference at all in the affidavit to the provisions of Section 8 of the TDA, and no facts to explain how the provisions of Section 8, subsections 3 and 5 of the TDA relates to the case or the complaints of the claimant. Let me also point out that it is not stated in the affidavit that there is a procedure in the TDA to be followed before the jurisdictional scope of trade union can be determined by the defendant. The only complaint made by the claimant in the affidavit in support of the originating summons is that the defendant's resolution communicated to the claimant in the letter dated 15th May 2020 was made when cases on the same issue were pending in court. The fact that the defendant issued the resolution when cases on the issue were pending in court is not a matter which arose from the construction of Section 8, 3 and 5 of the Trade Dispute Act. In other words, the fact that the resolution was issued when cases on the same issue were pending in court has no connection with the provision of Section 8, subsection 3 and 5 of the TDA, and it therefore amounts to an issue totally extraneous to the provision of Section 8, 3 and 5 of the TDA, which this court has been asked to construe. Originating summons procedure is principally for the interpretation of the Constitution, statutes, written instruments, or agreements. Thus, any person claiming to be interested under the Constitution or a statute or an agreement or any written instrument is permitted to bring an originating summons for the determination of any question arising from such a constitution, statute, written instrument, or agreement, and for a declaration of the rights of the person claiming to be interested in such constitution, statute, written instrument, or agreement. See Order 3 Rules 3 and 16(1) of the rules of this court. In this case, I find that the facts of the claimant's case do not disclose any interest or relevance or connection to the provisions of the Trade Dispute Act to be construed. I also find that the complaints of the claimant and the rights or relief sought by the claimant in the suit cannot be determined from the construction of the provisions of the Trade Dispute Act presented for construction. Let me add that the case of the claimant in the affidavit evidence did not raise any issue for construction of any provision of the Trade Dispute Act. Accordingly, I find the originating summons filed by the claimant to be defective, frivolous, and lacking in merit. Before I conclude this judgment, let me comment on the inapplicability of the provisions of the Trade Dispute Act to the dispute to which the minister intervened and issued the resolution being disputed by the claimant. Section 8 of the TDA, which the claimant anchored his case upon, is in Part 1 of the Trade Disputes Act. Section 1, subsection 1 of the Trade Dispute Act provides that where a trade dispute exists or is apprehended, the provisions of this part of this act shall apply in relation to the dispute. The effect is that the provisions of Part 1 of the act apply to settlement of trade disputes. Trade dispute has been defined in Section 48 of the Trade Dispute Act to mean any dispute between employers and workers or between workers and workers, which is connected with the employment or non-employment or the terms of employment and physical conditions of work of any person. See also section 54 of the Trade Unions Act. Now, the dispute on which the minister convened the conciliation meeting of 18th March 2020 and issued the resolution communicated to the claimant via the letter dated 15th May 2020, does that dispute qualify as a trade dispute as for the provisions of Section 8 of the Trade Dispute Act to be applicable or observed by the minister? Now, from the depositions in the affidavit in support of the originating summons, the dispute which the minister intervened and called the conciliation meeting for was a dispute between the claimant and the National Union of Hotel and Personal Services Workers. The dispute was between two trade unions, and the dispute was as to which of the two trade unions should unionize workers of aviation in-flight catering services companies. See exhibits A, B, and C of the affidavit in support of the originating summons. The dispute was not between employers and workers or between workers. Also, the dispute had nothing to do with the employment or non-employment or the terms of employment and physical conditions of work of any person. The dispute was merely a jurisdictional tussle between two trade unions. The dispute between the claimant and the National Union of Hotel and Personal Services Workers, on which the minister convened the conciliation meeting of 18th March 2020 and issued the resolution communicated to the claimant by the letter dated 15th May 2020, was not a trade dispute contemplated in the Trade Disputes Act. Therefore, the provisions of the Trade Dispute Act, particularly Part 1 of the Act on procedure for settlement of trade disputes, are not applicable to inter-union disputes of the nature the minister convened the conciliation meeting and for which the resolution was issued, as being challenged by the claimant. Consequently, the provisions of the Trade Dispute Act, which the claimant wants this court to construe in the originating summons, are clearly not relevant or applicable to the case of the claimant. In the result of all the foregoing, this suit lacks merit and it is accordingly dismissed. No order as to cause. Judgment is entered accordingly.
As the God pleases. My Lord, we are grateful for the judgment.
Thank you.
Apply to get a copy of it.
Yes, you get a copy. Hopefully, if you apply for it by today, hopefully before tomorrow, you should have a copy.
As God
Thank you
pleases.
very much.
We are very grateful, my Lord.
Thank you. Mohammed, I believe we are done for the day.
Yes, my lord.
All right. Do have
Thank
a
you.
nice day, all of you.
Thank you, my lord.
I will send an email to Victor so that,
Okay.
yeah,
Okay.
thank you. So I'll leave
Okay.
the meeting now. Thank you.
Thank you, my lord. Yes, ma'am.